talking while court's in session. Please silence cell phone. Before I give some of my rationale, and let me say that Section 58 of Chapter 119 requires that written findings be entered. I have done a draft of those findings, but I will do a final draft to incorporate the positions of the parties in this case and to reflect in that final decision on the impact of those arguments by Mr. Cataldo and Ms. Flynn. And of course, I had already read all of the letters that were reread to me here this afternoon, but certainly the effect of having them read to me by these people whose lives were so touched by Mr. Roy's passing was a consideration. I would say that those letters, those statements, the letters that accompanied Ms. Carter's sentencing memorandum, as I said earlier, gave a fuller understanding of both of these young people. But it also highlighted perhaps what has been the most poignant comment made by anyone in this trial, and that was by ADA Flynn, that this is a tragedy for two families. You need to understand, however, all of you, that this court has not, nor should it, allow any emotional response to this case to enter into its determinations in any way. Everyone is entitled to a decision devoid of any emotion with respect to this case. The relevant provisions of the law with respect to the juvenile court to this case are Sections 53 and Sections 58. Section 53 provides that notwithstanding the fact that, as Ms. Flynn so well pointed out, Ms. Carter was approximately 3 weeks away from what that law considers to be adulthood, she was still what Section 53 calls a child before the court. Section 53 says that children before the court charged with crimes are to be treated as children in need of aid, encouragement, and guidance. Section 53 preceded the youthful offender statute by many, many years. It is my opinion that Section 58 and the youthful offender statute, in fact, diluted somewhat the philosophy of Section 53, but the legislature, in its enactment of Section 58, the youthful offender statute, did not repeal Section 53. And so it is necessary that there be a balancing between the mandates of those two statutes. And that is what has guided this court. A comment on a few of the Section 58 considerations, and again, not to be misconstrued as the entire process or deliberative determinations. I have not found that Ms. Carter's age or level of maturity or even her mental illness have any significant impact on her actions. She was a bright young lady, did well in school, and I am satisfied that she was mindful of the actions for which she now stands convicted. So in my deliberations, that has had little weight. On the other hand, as Mr. Cataldo so well pointed out, I am aware of a huge body of law that has developed nationally and within this state starting primarily with a case in 2012, Miller versus Alabama, and then picked up here in Massachusetts in the matter of Diachenko versus the district attorney, which is found at 466 Mass. 655. Although Mr. Cataldo stated one side of it, it is my read of those cases that there is another side. And that is that even if the age and maturity level of the person at the time that they have committed the crime doesn't garner a great deal of significance, the fact that they are still of that young age offers a greater promise of rehabilitation. Now, I know that there has been some significant media coverage of this case. I assure you that I have steadfastly avoided any of that. It would not be proper, nor would I want to color any perceptions of my case by exposing myself to any of that. And I have not done so. But by the end of today, people will wonder why what has happened has happened. People may wonder why all of this has happened. If you really want to understand what we do in the juvenile court and how we come to the decisions that we make, it is all contained in this little pamphlet. This is a remarkable work that was issued by the Administrative Office of the Juvenile Court in April of 2016. It is the Dispositional and Sentencing Best Practices for Delinquent and Youthful Offender Matters. It came together by virtue of a committee that was chaired by an extremely knowledgeable judge, Judge Jay Blitzman, First Justice of Middlesex Juvenile Court, with several other highly knowledgeable juvenile court judges sitting on that same committee, as well as representatives from District Attorney's Office, CPCS, which represents the majority of children in the juvenile court, DYS, and many other agencies. When I first prepared my remarks for today, I took this book out and I started making purple marks on it and things that I would want to present to people to understand the context of what is going on. There were so many purple marks, I said I'm not going to do it. But if you really want to understand the juvenile court, read this document, because then you will understand what we are all about here. And as Mr. Cataldo said, we are the juvenile court, a unique and special aspect of the Massachusetts trial court. That document, Diachenko, Miller versus Alabama, all indicate that this court must and has considered a balancing between rehabilitation, the promise that that rehabilitation would work, and a punishment for the actions that have occurred. And so I have done so. Ms. Carter, please stand. Ms. Carter, a guilty finding having entered on the indictment charging you with the involuntary manslaughter of Conrad Roy III, now sentences you to 2.5 years in the Bristol County House of Correction. 15 months of said sentence shall be deemed a committed sentence, and the balance thereof shall be suspended until August 1st of 2022. You will be on probation, administrative, until you are released from incarceration, supervised thereafter, and the date of probation commences today. While you are on probation, there will be the usual conditions of probation, which include that you will obey all court orders and all local, state, and federal laws. You will report to your probation officer as that individual directs. You will allow the probation officer to visit in your home or school with or without notice. You will notify your probation officer within 48 hours if you change your residence, school, or employment. You will report to your probation officer within 48 hours after you are released from incarceration. You will not leave Massachusetts unless you get permission of your probation officer and sign a travel permit. You are required by virtue of your conviction to submit a DNA sample, and that will be done through the probation department. You will sign all releases as necessary for probation to verify your compliance with its terms, and you will pay all court-ordered fines, costs, and assessments. Those are the general terms. There are, in addition, specific terms. You are to have no contact with any member of the Roy family, excepting only that as may be necessary in conjunction with any civil litigation, including but not limited to the matter of estate of Conrad H. Roy III versus Michelle Carter, docket number 17-0846. You will have no contact, direct or indirect, with any of the civilian witnesses who testified at this trial, excepting only Dr. Bregan. This shall include, but not be limited to, Ms. Samantha Boardman, Ms. Alexandra Eblin, Ms. Ali Ethia, Ms. Olivia Mosoglo, and Thomas Gamble. Upon your release from incarceration, you shall present yourself within 48 hours to the Bristol County Juvenile Court Probation Department, Taunton Division, and thereafter shall follow all regulations as indicated by that probation department as to reporting requirements. When you report to probation, you will arrange through probation to schedule a mental health evaluation, which will be done by our juvenile court clinic. Said evaluation shall be for the purpose of addressing areas of need as to any mental health issues and to make recommendations for the treatment thereof. You will be required, as a condition of your probation, to cooperate with that evaluation and to follow those recommendations. A copy of the evaluation shall be provided to the probation department, but shall not be filed with the clerk's office. You shall also sign releases of information providing for any service provider from whom you are receiving services related to the mental health treatment to probation, allowing probation to receive information as to your attendance, the purpose and goals of your counseling, a general statement as to your cooperation with that service, and progress toward the stated goal. Said mental health services shall continue for as long as deemed necessary while you are on probation by the clinician or individual providing same. This court further orders, and this will be in writing, all of this is in writing, this court further orders that any disclosures made by Ms. Carter during the mental health evaluation or the treatment recommended may not be used in any substantive way at any subsequent evidentiary hearing that may occur relative to this matter to establish any of the elements of any crime, including this indictment, in the event that for whatever reason it is retried. Based upon this court's analysis, that to some degree, and drawing on Dr. Bregan's testimony, that he spoke in terms of behavior of grandiosity, and this court's assessment that for whatever reason, part of the motivation for this activity that led to your conviction was a sense of self-aggrandizement. This court now orders that you are not to profit from the events of which you now stand convicted and the facts surrounding same. For those counsel, I refer you to the case of Commonwealth versus Power, 42010, and the cases that are cited therein from 1995. You, Ms. Carter, your assignees, and any representatives acting on your authority are prohibited from directly or indirectly engaging in any profit or benefit-generating activity relating to the publication of facts or circumstances pertaining to your involvement in the criminal act for which you now stand convicted. This shall include contracting with any person, firm, corporation, partnership, association, or other legal entity with respect to the commission and or the reenactment of the crime by way of a movie, book, magazine article, tape recording, recording of any type, radio, television, or internet presentation, interview, live entertainment of any kind, or from the expression of your thoughts, feelings, opinions, or emotions regarding such crime. Any action taken by you, whether by way of execution of a power of attorney, creation of corporate entities, or like action to avoid compliance with this condition of probation, shall be considered a violation of the terms and conditions of your probation. As I noted, your probation shall be administrative until you are released from incarceration, and thereafter shall be supervised. The probation supervision fee is waived. A victim witness fee in the amount of $45 is imposed, and that shall be paid on or before September 11th of 2017. And finally, as I noted a moment ago, you will be required and must submit a DNA sample in accordance with General Laws, Chapter 22E. That is the sentence of the court. You may be seated. Mr. Cataldo, do you wish to be heard?
I do, Your Honor. May I approach?
You may. Thank you.
Your Honor, what I have just filed is a motion to stay the execution of the sentence.
All right, let me take a look at it, please.
Okay, thank you.
I'll hear you, sir.
Thank you very much, Your Honor. Your Honor, you have now reviewed the motion to stay the execution of the sentence. Your Honor, the issue is that not whether or not the defense, we need not establish that the appeal is more likely than not to be successful, but only that it presents an issue which is worthy of presentation to an appellate court, one which offers some reasonable possibility of a successful decision on appeal. Your Honor, I have, this is not an exhaustive list by any means, but I refer the court back to the motion for required finding of not guilty for other issues that we presented during the course of the trial, as well as some issues that have been presented in the court's ultimate decision to find Ms. Carter guilty of involuntary manslaughter. I would argue to the court, and I do argue to the court, that this is a very unique and, despite the court's findings, novel issue involving speech alone, without presence, without physical presence. As the SJC even noted in their decision that went up pre-trial on a probable cause standard, they had never encountered a case where speech alone, where there wasn't physical presence, had come up before. I suggest that this is a fertile ground, a very important legal issue that needs to be pursued in the appellate courts for however long it takes to whatever court needs to address this very issue. There are many different issues involved in the appeal that will be coming. You have the Levesque issue, as the court noted, that she owed Conrad Roy a duty of care by a self-imposed created duty. While the judge yourself said that, we do take exception that the fire, if you will, was not created by Ms. Carter, but was created by Mr. Roy. That's another issue that we would be presenting to an appellate court. This court has already, and I won't go through each and every one of the motion for required finding, but I think this court is, it realizes that there are many issues in this trial and the uniqueness of a manslaughter without a statute for assisting suicide and the implications on the First Amendment that this case will have or could have once an appellate court ultimately rules on the First Amendment. So, Your Honor, the idea that even if the appellate court were to deny it, these are legitimate issues that are worthy of presentation, and it's something that the appellate court will ultimately may not rule on by the time Ms. Carter, if she is ordered to serve her sentence immediately, would already be out, would already be released. So for those reasons, Your Honor, we think that this court should issue a stay of the execution. She would be on probation immediately. She would have to do everything else and begin with all her conditions. But the incarceration portion could never be taken back if the court does not stay that particular issue. Further, Your Honor, as this court knows in issuing whether or not, in deciding whether or not to issue a stay, is whether or not Ms. Carter might be a flight risk. I think that is extraordinarily minimal in this case, that she would be a flight risk. She's always appeared in court for the past 2 years while this case has been pending. She has not defaulted. She obeyed each and every term and condition of her pretrial release. I would suggest that she will go ahead and start with her probationary conditions, but just we're asking to stay the portion of the sentence that would dictate that she be incarcerated immediately. Your Honor, there are a lot of legal precedent, not just in Massachusetts, but from around the country, on the issues of whether or not speech without using true threats can be curtailed without a statute in place. These issues need to be litigated in an appellate court ultimately, and we're asking you, Your Honor, to stay the jail sentence until we can have our day in court in the appellate level of whichever court ultimately it goes to be the final arbiter determiner of the First Amendment, as well as the idea of the duty imposed on Michelle Carter and all the other issues on the motion for required finding of not guilty, some of which, Your Honor, were not presented on Commonwealth v. Carter, the SJC previously issued in 2016. There were some other issues, as this court notes. So for those reasons, I'm asking the court to stay the execution of the jail sentence of this case.
Mr. Cataldo, before you step away from
Yes.
the podium, sir, assuming I was to allow this motion, I have some concerns that extending a stay until the federal appeals are done might create two problems. And the first is that the statute seems to suggest that the stay ends when the rule seems to suggest that the stay ends when the appeals court issues its rescript. So how would I be able to extend a stay beyond the issuance of a rescript by the Massachusetts Appellate or SJC? And then the second issue is, assuming that this wended its way through the federal court system, the date of August 1st, 2022 could have come and gone before Ms. Carter is required to serve her sentence in the event that ultimately my decision is upheld.
First question, Your Honor, on the rescript, I would suggest if a rescript were to come down and it is in Ms. Carter's favor, and secondly, if it came down against Ms. Carter's appeal on all the various issues, I would suggest, depending on which court, we would be asking that court at that time for a further stay.
Which I think begs my question of why, if I am to allow a stay, why should it not just be through the Massachusetts appellate court system? And then beyond that, you would have to obtain relief from the appellate level.
Well, I guess let me start by saying that is now my fallback position to this court. But I do think each and every level as we go up, and if it is ultimately denied by the SJC and there is a petition for cert or some other federal relief that we are looking for, then it would be incumbent upon the government move to terminate your stay at that time. But I think that the court should issue the stay and through all appellate procedure, but at least through the SJCs, and then if the court were to put the burden, if you will, for lack of a better word, over to the defense, I'm sure we'd be seeking it in a federal court. But if not, then I suggested it be on the government to then file for a revocation of the motion to stay.
Well, I think under the rule, clearly, once the rescript opinion issues, it is on them. But, and I suppose I should say at this point in time that although I have been very involved in this case, no one should assume that I have taken exclusive jurisdiction of it. all right, because I don't know how much longer I will be here. So in any event, please feel free to bring whatever concerns you have in front of any juvenile court judge. Thank you, Mr. Cataldo.
Thank you, Your Honor.
Ms. Flynn and Ms. Rayburn, do you wish to be heard?
Yes, Your Honor. Commonwealth vehemently would ask the court to deny the motion. The main issue in this case is that the defendant was convicted of involuntary manslaughter. This is not an assisted suicide case. This is not a First Amendment case. The SJC unanimously said that. There is no basis or likelihood of success for her appeal. This is a case that has been a 3-year ordeal for the Roy family. They deserve to have the sentence that you just handed down imposed today. And so the Commonwealth would suggest that this motion be denied.
All right, thank you very much. I guess we have all come to know each other a little bit. I anticipated this motion, Mr. Cataldo, and I took some significant time to review the case of Commonwealth versus Hodge, which is found at 380 Mass 851. I note at page 855 of that decision they are talking about the significance of stays, even though the reporter's notes indicate that stays are not generally the practice here in Massachusetts. It does say, however, that the practice of a stay is grounded in rudimentary notions of justice, that a person convicted of a crime who would a short sentence would otherwise be made nugatory in the case of a short sentence and would be impaired in the case of a larger sentence, and says further, citing Commonwealth versus Levin, 7 Mass App Court 501, the conviction may be reversible, but the time spent in prison is not. I am satisfied under the Hodge language that there is an issue worthy of presentation to the appellate court. In fact, this court believes that the wisdom of the appellate court will be of instruction now and going forward. And that's important. And one of the reasons it's important, Ms. Flynn and Ms. Rayburn, as the representatives of the Commonwealth of Massachusetts, and specifically the Roy family, is the letter of Mrs. Roy, who said that she hoped that the death of her son would result in law that could prevent this from ever happening again. I don't know what the appeals court will do. I don't know if it goes to the SJC, what the SJC will do. But I am satisfied that a grant of a stay through the Massachusetts court system only is warranted. This order will not encompass anything with respect to the federal system. Now, while Ms. Carter experiences the, apparently I have to file this. I'll give this to probation. I have the notice of the DNA. I will give that to probation to go over with Ms. Carter afterwards. All right, and let me give you that now before I forget. Thank you very much. Ms. Carter is going to be out on the stay, and she is going to be, under Rule 31, I have the authority to issue conditions, and that has been enhanced by the use of Chapter 276, Section, I'm sorry, wait a minute. 276, Section 87. So Ms. Carter will be, although they call it pre-release on the form, it is obviously post-trial, but it applies. And there will be conditions which will track in large measure the conditions of probation. Violation of any of those conditions could result in the immediate revocation of the stay. And I have those written out. I just have to see if I can locate them amongst all my papers. Ms. Carrera, here are the, that's a motion for funds. You can distribute them to the lawyers, and you can give Mr. Cataldo and Mr. Madeira 2 copies so that they have it for the sake of that. I believe there are 2 copies there. Okay? All right. I apparently must have left that other form on my desk. Do you have a copy? Is that, it's on my copy? That's all right. I remember most of it. All right, that will be provided to the probation in about 5 minutes, Mr. Cataldo. But basically, it is the same existing conditions. No contact with the Roy family, no contact with the witnesses, no application for or obtaining of a passport, no leaving the Commonwealth of Massachusetts, and the language from Commonwealth versus Power are all incorporated in the 276-87 order that will enter. And probation will have that in 2 minutes. I must have just inadvertently left it on my desk upstairs. Is there anything further, Mr. Cataldo or Mr. Madeira?
We're all set. Thank you.
Commonwealth.
Your Honor, if I may,
Yes.
request, given the court's ruling, if Your Honor could order an expedited assembly of the record. Usually that takes a little time.
I'm happy to order that. I don't know, do you need a motion?
I may, Your Honor.
All right, if you write it out and give it to the clerk, I'll make sure I endorse it before I leave today.
Absolutely.
But certainly that is allowed.
Could I do a handwritten motion, Your Honor, without the
That's
acceptance of
fine.
the clerk?
Just
Thank
as
you
long as
very
I can read it. That's right. All right.
Yes, Your Honor, absolutely.
Anything further?
No, nothing further on behalf of the Commonwealth. Thank you.
All right. Ms. Carter, please wait to meet with probation, and we are adjourned. Thank you very much. All rise. Sue, I'll bring this down to you in a couple of minutes. Okay? All those conditions are all written out, Sue. No. Yeah. Right here? All right. No, don't, come upstairs.
Orderly fashion, please.
So you got that off, right? Thanks.
There, guys, you saw an outside shot there of the Massachusetts courthouse where we finally seen a sentencing in the highly anticipated case of Michelle Carter. This was the so-called texting suicide case. There you see shots from earlier today and throughout the trial of Carter. Carter was, of course, 17 at the time that her 18-year-old boyfriend ended up committing suicide. She was convicted in June of this year when a judge decided that it was her final instruction to her then boyfriend, Conrad Roy, over text that ultimately caused his death. And in the sentencing today, we heard the prosecution ask for 7 to 12 years. We heard the defense there make sure that the judge knew that she was a minor at the time, asking that the punishment be rehabilitative and not punitive, asking just for probation. In the end, the judge sentenced Carter to 2.5 years, 15 months of which would be a committed sentence, and a number of other amendments added on to that as well, conditions such as no contact with the Roy family, and a long discourse as well that she in no way profit from anything related to this case, any of the details of the case, any of her experience with the trial, any of her thoughts or feelings thereafter. We're going to dig into all of this in just a little bit with my colleague outside of the courthouse. But this has been a case that has been the subject of intense media scrutiny, the judge himself referencing all of the attention paid by media outlets to the case, of course, because what stands here is that this was text messaging between two teenagers. And as the judge also mentioned there, this can only be considered a tragedy for two families. All of that being weighed by the judge there in that courtroom. Let's go live now to my colleague Deborah Roberts, who was inside the courtroom during that sentencing, has been following this case and joins us live outside the courthouse now. Deb, help us to put that sentence that so many people have been waiting for into the context of this case.
Well, Amna, you could see that Judge Lawrence Moniz was really wrestling with this case. As you know, this has been a very complicated one. Many people arguing that this was a First Amendment case, that words can't kill, that it's so unusual to actually prosecute and then convict somebody of manslaughter because she text messages somebody to kill himself. The judge really wrestled with this, even though he had found Michelle Carter guilty in this case and seemed to be confident that he found the right decision there. This one was far more difficult. As you said, the state was asking for at least 7 years. Michelle Carter was facing up to 20 years in prison, but the judge seemed to be trying to find a way to split the baby down the middle, as it were. And he even said that, trying to find some balance. She was 17 years old when this crime was committed, just 3 weeks shy of her 18th birthday, though the state pointed out, very close to being an adult. And the judge wrestled there and decided that 2.5 years in county jail, too, I might add, as opposed to prison. He offered 2.5 years in county jail, 15 months for her to serve. But in a very unusual move, her attorneys immediately pounced and asked for a stay, which basically kept her out of jail tonight. Michelle Carter is not going to jail tonight because they want to argue, they want to make an appeal. And they asked the judge for a stay while they try to appeal part of her conviction. The judge seemed to understand that there may be some areas there where they could possibly make an argument for an appeal. So Michelle Carter, yes, sentenced to 2.5 years in jail, but tonight going home with her family and working out conditions of probation while they decide when and if this appeal will go forward.
Deb, we heard from the judge there before he handed down the sentence, saying that some of the letters that had been submitted on behalf of both families there gave him a fuller picture of both these young people. You were there in the courtroom when some of those statements were made. What was it like in there?
Well, you could cut the tension with a knife in this courtroom. I mean, it was packed. I mean, there was standing room only. And on the one side, of course, supporters of Michelle Carter, her family members, looking all stricken. On the other side, Conrad Roy's family members, of course, looking heartbroken. And just sort of a tale of two families, heartbroken families, as the judge said in this case. I don't think there was really a dry eye on the side of Conrad Roy when his younger sister got up and read that heartfelt note about missing her brother and having him here all her life and losing her best friend. And also the emotional comments from his father, talking about losing the future and the promise. His father has a tugboat business, and Conrad was a part of that business, and he talked about him never being able to realize his future and what that would mean. A very, very emotional appeal from the family, and it seemed to weigh on the judge as well. He talked back and forth about the two sides, trying to balance punishment for this young lady, but also a sense of some compassion and rehabilitation, as it were. So I think that there's a perplexed group of folks coming out of this courthouse tonight. The family members probably feeling relieved that there was some jail time, but not quite sure what this all means with this appeal, and will she go to prison at some point? And of course tonight she is not going to prison, but she has of course been given a sentence, and we'll have to now wait and see how this goes through the courts and what happens next.
You know, Deb, in all the coverage of this trial, there's been so much attention paid to the details of those texts, those thousands of messages between the two of them. Today, it seemed like, especially from the judge's comments, there was a lot of focus put on their ages. Obviously, the Conrad Roy's family was talking about how young he was and how there are so many years ahead that he will never see, his family will never experience. And the judge also mentioning, of course, that this young woman could have a potential rehabilitated future ahead of her. Talk to me a little bit about that, about how big of a factor their age was in this case.
Well, one of the things that's been really fascinating about this case, and I think the reason it has resonated around the country, is because it does tap into something that is happening right now in our culture. Teenagers living online, texting online, creating whole lives that maybe their parents don't even know about. In both of these cases, the parents didn't really know much, if anything, about the other, and had no idea that these kids were in the kind of pain that they're in. And the judge touched on that Michelle was 17 years old when this happened. Conrad was 18 years old. The police officer who discovered Conrad's body I spoke with earlier today, he talked about remembering himself what it was like to be an awkward teenage boy and to feel bouts of depression, that teenagers everywhere go through this. So I think if anything, this case has shown a bright light on our teenagers, some of the anxiety, some of the mental health issues they may be grappling with. Add to that the online aspect of it, the texting, the intense texting that goes on, and these private cyber relationships. I think that in a lot of ways, too, the judge was trying to recognize this, that you're talking about kids, and Michelle was indeed 17 years old when this happened. So for that reason, I think he was trying to find a way to show a little bit of compassion for the idea that teenagers do get themselves into something that may be in over their heads, but at the same time, very serious things can result, which in this case it did result in the suicide of a young man who apparently had so much promise and of course now has left two families shattered.
Tragedy for two families, indeed. Deb Roberts, outside the courthouse in Massachusetts. Thanks so much, Deb. Good to talk to you. And thanks to all of you for watching as well. Remember, if you want to get the latest on that case, head over to abcnews.com right now or anytime. We'll be updating the story as we learn more. Thanks for joining us for now. I'm Amna Nawaz, and I'll see you back here soon.